Alrighty, alrighty. Your favorite auditor, the one who encourages you to audit them. Let's get ready to audit all them. Let's get ready to audit all them. Testing, testing. Testing, the test is being testing. Let's get ready to audit lamb. Test is being tested. Testing. Jenny, hello there. Testing, testing. Alrighty. Volume is low. Testing, the test is being testing. Let's get ready to audit lamb. Audio's good? Alrighty. So, we're going to be going over the OMA Open Meetings Act. I have read this in the past, a few years ago, but we need to follow back up. So please, upon entry, hit the thumb up so we can get more people in here. Knowledge is the key to success. Open Meetings Act is as powerful as the Freedom of Information Act. Almost. No, the audio's something wrong with the audio. Audio's low, is it? If it's fine, we'll continue. Sound is good. Okay, that's the second confirmation. Let's go ahead and continue. Alrighty. So with that being said, let's open up the state code here. So we're gonna go to Public Acts. Well, let's go to Compiled Statutes. Let's go to General Provisions. Let's go to 120 OMA. Alrighty, once we're here, let's zoom in. Like this. Now what we're going to be doing, guys, is we're going to skim through it, okay? Like I said, I've read this in the past, but we're just going to skim through it. We're not going to read it all. Hey, MB is asking question, what is the law on filming in a police station lobby? They have a signs, no law attached, saying it's an offense that you can be arrested for. What state are you referring to? And what state is the police station in? And what exactly does the sign say? Alrighty. So here we are. We're going over the OMA. Like I said, we're going to skim through it. Let me zoom in on this screen. And let me zoom in a little more here. Okay, I think that should do it. Okay. So you guys see when I'm highlighting it too? Oh. Okay. Alrighty. OMA, Massachusetts. You gotta do a little digging on that, man. If it doesn't have no statute, then what exactly would they be charging you with? Boston, yeah. It's probably hogwash. You gotta challenge that. Section 1, policy. It is the public policy. Some of this language is similar to the FOIA Act. So we're at 5 ILCS 121, policy. It is the public policy of the state that public bodies exist to aid in the conduct of the people's business, and that the people have a right to be informed as to the conduct of their business. This is big talk right here, guys. Hit the thumb up, please, upon entry. in order that the people shall be informed. The General Assembly finds and declares that it is the intent of this act to ensure that the actions of public bodies be taken openly and that their deliberations be conducted openly. Beautiful. Let's go ahead and continue here. The General Assembly further declares that it is the public policy of the state that its citizens shall be given advance notice of and the right to attend all meetings at which any business of a public body is discussed or acted upon in any way. Exceptions to the public's right to attend exist only in those limited circumstances where the General Assembly has specifically determined that the public interest would be clearly endangered, or the personal privacy or guaranteed rights of an individual would be clearly in danger or unwarranted invasion. That's hogwasher. So Mike is saying in New York, the one auditor that could film is Long Island. I'll give him about a year and a half till he starts reading the FOIA law to his subscribers. So MB says, notice order of the Boston Police. These premises are reserved for Boston Police Department functions. These premises are not a public forum. The police commissioner prohibits the... Okay, so here's the next step, MB. If they're telling you it's a police order, then get a copy of their order. And that'll be the next step. Let's read their order word for word. But before that, they're telling you, they're claiming on that poster that it's not a public forum. That's why you have to read the Massachusetts Public Record Act, because that's going to tell you the right word. It's either going to call it, possibly a public body. The public forum, that's just a made-up word that they're using. Public forum photography, video recording and audio recording on these premises. The police commissioner also prohibits public assembly. Oh my God, demonstrations and expressive conduct. Well, if it's telling you that the commissioner is prohibiting public assembly, so what does that tell you about the First Amendment? Freedom of assembly. That sounds like hogwash. That's null and void. Man, listen, the best info that I could tell you is read your Massachusetts Freedom of Information Act. Let me continue here. Okay. So, to implement this policy, the General Assembly declares it is the intent of the Act to protect citizens' right to know, and the provisions for... Could we see what we're looking at? Yep. And the provisions for the open meeting requirement shall be strictly construed against closed meetings. I like that. This act shall be known and cited as Open Meetings Act. Meeting means any gathering. Here's where we're going good. When these employees start saying, oh, the FOIA officer's in a meeting, oh, the clerk is in a meeting. Okay, for the purposes of this act, meeting means any gathering, whether in person or by video or audio conference. Telephone call. So a telephone call is a meeting, right? Electronic means such as, without limitation, electronic mail, electronic chat, and instant messaging, or other means of correspondence or contemporary interactive communication of a majority of a quorum of the member of the public body held for the purposes of discussing public business, or for a 5-member public body, a quorum of the members of the public held for the purpose of discussing public business. According for 5-member public, what this does here is it repeats some of the same stuff. Accordingly, for a 5-member public body, 3 members of the public constitute a quorum, and that the affirmative vote for 3 members is necessary to adopt any motion, resolution, or ordinance greater than the number otherwise required. Public body. Now here's what defines a public body. This is the same definition in the FOIA Act. A public body includes all legislative, executive, administrative, or advisory bodies of the state, counties, townships, cities, villages, incorporated towns, schools, districts, and all other municipal corporations, boards, bureaus, committees, and commissions of the state, and any subsidiary bodies of the foregoing, including but not limited to committees and subcommittees which are supported in whole or in part by tax revenue. Damn. Or which expand tax revenue, except the General Assembly and committees or commissions thereof. Public body includes tourism boards and convention or civic center boards located in counties that are contiguous to the Mississippi River, with populations of more than 25,000 but less than 300,000. Public body includes health facilities and service review board. Public body does not include a child death review team or the Illinois Child Death Review Teams, an ethics commission acting under the State Officials and Employees Ethics Act, a regional youth advisory board of the state, okay, yada yada. So meeting means any gathering. We read that one right there. That was above. So, and then this just repeats the same statute again. Okay, training. We know that for Open Meetings Act, it's required annual training program. So let's go ahead and start reading this. Training. Every public body shall designate employees, officers, or members to receive training on compliance with this act. Each public body shall submit at least submit a list of designated employees, officers, or members to the Public Access Counselor within 6 months after the January 1st, 2010. The effective date of the Public Act of 96-542, the designated employee, officers, and members must successfully complete an electronic training curriculum developed and administered by the Public Access Counselor, and thereafter must successfully complete an annual training program. Thereafter, whenever a public body designates an additional employee, officer, or member to receive this training, that the person must successfully complete the electronic training curriculum within 30 days after that designation. Except as otherwise provided in this section, each elected or appointed member of the public body subject to this act, who is such a member on the effective date, must successfully complete electronic training developed and administered by the Public Access Counselor. For those members, the training must be completed within 1 year. Except as otherwise provided in this section. Except otherwise as provided in this section, each elected or appointed member of the public subject to this act who becomes a member oh, sorry, you guys couldn't see what I'm zoomed into. Let me try to make the screen smaller. 1 minute. There we go. Okay, well, let me zoom in a little bit more. Zoom out, rather. There we go. Okay. Alrighty. So let's continue here. Shall successfully complete the electronic curriculum developed and administered by the public access counselor. Number 1, take an oath of office. If the member is required to take an oath of office to assume the person's duties as a member of the public or otherwise assumes responsibilities as a member of the public. If the member of the public is not required to take an oath of office and assume this person's duties as a member of the governmental body, each member successfully completing the electronic training curriculum shall file a copy of the certificate of completion with the public body. Completing the required training as a member of the public body satisfies the requirements of this section with regard to the member's service on a committee or subcommittee, or the public body and the members ex officio service as other public body. The failure of one or more members of a public body to complete the training required by this section does not affect the validity of an action taken by the public body. I gotta brainstorm on that one. Let me take a photo here. Alrighty, let's see. So an elected or appointed member of the public subject to this act who successfully completed the training required under this section and filed a copy with certificate of completion with the public body is not required to subsequently complete the training required under this section. An elected school board member may satisfy the training requirements of this section by participating in a course of the training sponsored or conducted by the organization created under Article 23 of the School Code. The course of training shall include, but not limited to, instructions in number 1, the general background of legal requirements for open meetings. 2, the applicability of the Act to public bodies. 3, procedures and requirements regarding quorums, notices, and record keeping under this Act. 5, penalties and other consequences for failing to comply with this Act. Okay, this is a good one too. If any organization created under Article 23 of the School Code provides a course of training under this subsection C, it must provide a certificate of course completion to each school board member who successfully completes the course of training, that course of training. D, a commissioner of the drainage district may satisfy the training requirement of this section by participating in a course of training sponsored or conducted by an organization that represents the drainage districts created under the Illinois Drainage Code. The course of training shall include, but not limited to, instruction in the general background for, okay, this is all the same shit. Penalties. A director, okay, all right, beautiful. So director of soil, an elected member of the public body, same gig. Alrighty, let's go ahead and continue. An elected appointed member of a board of trustees. Alrighty, beautiful. If an organization that represents fire. Alrighty. So open meetings. Now we're at 120/2. This is just for the state of Illinois. Open meetings. Section A. Openness required. All meetings of public bodies shall be open to public unless accepted in subsection C and closed in accordance with section 2A. Okay. So section C is going to tell us, we'll see what C tells us, but let's go to section B. Construction of exceptions. The exceptions contained in subsection C are in derogation of the requirement that public bodies meet in open, and therefore the exceptions are to be strictly construed, extending only to subjects clearly within their scope. The exceptions authorize but do not require the holding of a closed meeting to discuss a subject included within an enumerated exception. I'm going to have to read this stuff a few times. C. Exceptions. A public body may hold closed meetings to consider the following subjects: the appointment, employee compensation, discipline, performance, or dismissal of a specific employee, specific individuals who serve as an independent contractor in a park, recreational, or educational setting, or specific volunteers of the public body, legal counsel for the public body, including hearing testimony, complaint lodged against an employee, a specific individual who serves as an independent contractor in a park, recreation, or educational setting. See what they're telling us here? They're telling us all meetings are open to public. So when they tell you a FOIA officer's in the meeting, well, if he or she is not discussing, attorney-client privilege, everything else should be open. Attorney-client privilege, or here's legal counsel, or you got independent contractors, independent contractors in a park, recreation, or educational setting. That's beautiful. Or volunteer. You see what we're doing here? What's normal? The FOIA, a lot of these towns now, they're starting to say the FOIA officer is in a meeting, or there's the clerk is in a meeting, or the mayor is in a meeting, so he's not available. So what do we have to do next? We have to read the Open Meetings Act. So if they try to spew some hogwash on us, some nonsense, we could say the right way. So let's go ahead and continue. I'm telling you, the other auditors, they'll probably start picking this stuff up. Give them about a year, 2 years. Or a volunteer of the public body. So, however, a meeting to consider an increase in compensation to a specific employee of a public body that is subject to Local Government Wage Increase Transparency Act may not be closed and shall be open to the public and posted. Okay, beautiful, beautiful. But that's neither here nor there. The main thing is what it says at the top. The main thing is telling us that this act, the provisions, it is the intent of this act to protect the citizen's right to know. Let's go ahead and continue here. Nevertheless. Okay, so what else is an exception? What else don't they have to be open to? Is collective negotiating matters between the public body and its employees on their representatives, or salary schedules for one or more classes of employments. They don't have to be open on that. The selection of a person to fill a public office as defined in this act, including a vacancy in a public office, when the public body is given the power to appoint under law or ordinance, or the discipline, performance, or removal of the occupant of a public office. when the public body is given power to remove the occupant under this law. Okay, evidence, we're going to zip through these exemptions. Evidence or testimony right. The purchase of a lease of real property for the use of the public body, including meetings held for the purposes of discussing whether a particular parcel should be acquired. All right, these are all exceptions. They don't have to, if they're discussing any of this stuff, it does not have to be an open meeting. Student disciplinary cases, that's for the school district. The placement of individual students in special education already. Litigation when an action against, affecting, or on behalf of the particular public body has filed and is pending before a court or administrative tribunal. Or when the public body finds that an action is probable or imminent, in which case the basis for the finding shall be recorded and entered into the minutes of the closed meeting. See, closed meeting, that's the key word. They could do all this behind closed doors. Oh well, we're sorry, but so here's the good part. If they tell us the FOIA officer or the clerk is on a meeting, 5 days later, 10 days later, when we request the meetings, the day schedule, and it says that indeed that employee was, well, we're going to take it one step at a time. The establishment of the revenues, the establishment of reserves or settlement. Okay, we're going to zip through this. Informant sources, confidential, professional ethics and performance when considered by advisory body appointed to advise a licensing. So advisory body is their attorney. We're not going to get into too much depth with that. Self-evaluation, that's exempt. Alrighty, discussion of minute meeting lawfully closed under this act. Okay, beautiful. A lot of this shit is exemptions. So now here we're going back into definitions, it looks like. Yep, definitions. Employee means a person employed by a public body whose relationship with the public body constitutes an employee or employer. What's this? Employer-employee relationship. Yep, employer-employee relationship under the usual common law rules and who is not independent contractor. Great. Public office means a position created by or under the Constitution. I like that. Or laws of the state. The occupant of which is charged with the exercise of some portion of the sovereign power of the state. The term public office shall include members of the public body. Beautiful. But it shall not include the organizational positions filled by members thereof, whether established by law or by public body itself, that exist to assist the body in the conduct of its business. Quasi-adjudicative body means an administrative body charged by law or ordinance with the responsibility to conduct hearings, receive evidence or testimony, and make determinations based thereon, but does not include local electoral boards when such bodies are considering petition challenges. Yeah, that's pretty cool. What's normal? We gotta get you on the horn, bro. Section E, final action. No final action may be taken at closed meeting. Final action shall be preceded by public recital of the nature of the matter being considered and other information that will inform the public of the business being conducted. Alrighty. Open meetings. So it looks like this is a compiled. Yeah, this is just telling us the same shit over. I don't know why they do this. It's like they put the same info twice. Hey, Napoleon, how's it going? He said, what is it that you're reading here? Well, this is OMA, Open Meetings Act. So, public office, yep, we read all this. Here we go. 12201. All meetings required by this act to public shall be held at specific times and places which are convenient and open to the public. No meeting required by this act to be public shall be held on a legal holiday unless regular meeting day falls on that holiday. Except as otherwise provided in this act, a quorum of members, a public body must physically present at the location of an open meeting. If, however, an open meeting of a public body, number one, with statewide jurisdiction, two, the Illinois library system web with jurisdiction over a specific geographical area of more than 4,500 square miles, three, that it is a municipal transit district with jurisdiction over a specific geographic, this is the shit I'm going to have to brainstorm and audit them at a later time, specific geographic area of more than 4,500 square miles. 4, that it is a local workforce investment area with jurisdiction over a specific geographical area of more than 4,500 square feet. Okay, yada, 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 yada. Yeah, I might have to scribble through this at a later time. Okay, let's skim public notice. Each public should give notice. Okay. So let's get to this right here. Public notices of all meetings, whether open or closed, to the public shall be given as follows. This is a good one. A. Every public body shall give public notices of the schedule of regular meetings at the beginning of each calendar or fiscal year and shall state the regular dates, times, and places of such meetings. An agenda for each regular meeting shall be posted at the principal office. That's what they prominently display usually, of the public body and at the location where the meeting is to be held at least 48 hours in advance of the holding of the meeting. A public body that has a website that the full-time staff of the public body maintains shall also post this information on its website. The agenda of any regular meeting, a governing body. Any agenda of the regular meeting that is posted on public body's website shall remain posted on the website until the regular meeting is concluded. The requirement of a regular meeting agenda shall not preclude the consideration of items not specifically set forth in the agenda. Public notice of any special meeting except a meeting held in the event of a bona fide emergency, or any rescheduled regular meeting, or of any reconvented meeting. Reconvend. Let me look that up. Reconvend. What the hell? Reconvened. Reconvened. Reconvene. Reconvened. Okay. I'm only human. Reconvene. To come together again. Okay. Reconvene, yep. To come together again meeting shall be given at least 48 hours before such meeting. Okay. All right, we're gonna skim through this shit. No, this is really. We gotta skip. We gotta read through this. We can't skim through this one. Okay, shall be given at least 48 hours before such meeting, which notice also include the agenda for the special rescheduled or reconvened meeting, but the validity of any action taken by the public body which is germane to a subject on the agenda shall not be affected by other errors or omissions in the agenda. The requirement of public notice of reconvened meetings does not apply to any case where the meeting was open to the public. Reconvene announcement, yada yada. Notice of an emergency meeting shall be. Okay, public B. Section B. Public notice shall be given by posting a copy of the notice in the principal office. Okay, yeah, we're gonna skim through it. Any agenda required under this action shall be set forth. Yada yada. In addition, 203. In addition to the notice required by section 202, each body subject to this act must, at the beginning of each calendar fiscal year, prepare and make available a schedule of all its regular meetings for such calendar or fiscal year, listing the times, dates, and places such. I could bring this up to their attention. If a change is made in regular meeting dates, at least 10 days notice of such change shall be given by publication in a newspaper or general circulation in the area in which such functions. However, in the case, yada yada. Okay, the notices requirement of this act in addition. Alrighty. Recording meetings, minute right to speak. Recording meetings. Subject to the provisions of this section 8701 of this Code Civil Procedure, any person may record, I like that, the proceedings at meetings required to be opened by this act by tape, film, or other means. We all know that. You could record in a meeting. The authority holding the meeting shall prescribe reasonable rules to govern the right to make such recordings. If a witness at any meeting required to be open by this act, which is conducted by a commission, administrative agency, or other tribunal, refuses to testify on the grounds that he may not be compelled to testify if any portion of the testimony is to be on broadcast or televised or in motion picture are to be taken off him while he is testifying, the authority holding the meeting shall prohibit such recordings during the testimony of the witness. Oh, wow. Nothing in this section shall be construed to extend the right to refuse to testify at any meeting not subject to the provisions of this section, or of section 8701. Minutes right to speak. All public bodies shall keep written minutes of all their meetings, whether open or closed. Oh my God. And a verbatim record of all their closed meetings in the form of audio or video recordings. Oh shit. This is the part we were looking for. What's normal? This is the part we were looking for. The time, date, and the place of the meeting. The members of the public recorded as either present or absent, and whether their meetings are physically present. Okay, great fucking thing. What's normal? Great fucking thing. So what's normal? Here's the beautiful part. This is what we have to see. This was all the way at the fucking bottom. So this is what we have to attach on our updated clipboard. Listen to what this says again. Well, let me continue reading here. Well, let me repeat this. This is one reason they don't want camera. No, that's not one reason why they don't want camera. This is all this is telling you is that the clipboard has been updated. Because look at what this is telling you right here, bro. not necessarily the right to speak part, right? But Section A, all of this, it's telling us, let's say, for example, they tell us, I'm sorry, the FOIA officer is in a meeting. This is when I'm going to say, okay, I think you're lying to me now, and I'm putting in a public record request right now to be certified. I want the minute meetings of the employee having the meeting right now. I want those meetings certified as a FOIA response. So there's no way they could get away with that. If they lie to you, that means they're going to say no responsive records. Well, wait a minute. You told me there's a meeting, so there has to be minutes to it. And why do I say that? It's because it specifies that in 5 ILCS 122.06. So all public bodies shall keep written meetings of all their meetings, whether open or closed. Do you hear what I'm telling you? So whether their meeting is open or they're behind closed doors, they have to keep meetings and a verbatim record of all their closed meetings in the form of audio or video recording. Man, that's so fucking strong. Hey, T-Dotter, we found the spigot. We found the spigot. Now we got unlimited fresh water. Hey, T-Dotter, we found the spigot. Now we got unlimited fresh tap water. Okay? Forget about this part where it says minute right to speak. Then we'll probably look into that a little bit later. But focus on this part right here. All public bodies shall keep written minutes of all their meetings, whether open or closed, and a verbatim record of all their closed meetings in the form of audio or video recording. Minutes shall include, and here's more power to it. Exactly, there fuck you go. Minutes shall include, but not limited to, the date, time, and place. Oh, I'm sorry. So this means if I'm in the city hall at 4:04 p.m. and another employee says, I'm sorry, our FOIA officer's in a meeting right now, I'm going to say, okay, great. Whether I believe that employee or not, I'm going to say, great. I'm putting in a public record request for that employee's minute meetings, and well, they better respond with that date and time accordingly. Because if not, it's just going to show a bad faith. It's going to show them as, deceiving. Right? FOIA officers at a meeting, great, especially if you're in a city where they require oral request. But let's go ahead and continue here. The members of the public body recorded as either present or absent, and whether the members were physically present or present by means video audio conference. And number 3, a summary of discussion of all matters proposed. Right, that's what the fuck a meeting is about. A summary of discussion. You gotta have a summary. How the fuck can you be running a meeting without having a goal, a topic in a government? A summary of discussion. Man, T-Dot, I'm telling you, of either two things. Okay, a summary of discussion or all others matters proposed, deliberated, or you see, we had to read through all this fluff bullshit just to get to the bottom of the page. Okay. A public body shall approve the minutes of its open meeting within 30 days after the meeting, or at the public body's second subsequent regular meeting, whichever is later. Oh, but I'm sorry, it hasn't been approved yet, so we can't give you these precise minute meetings. So the minutes of the meetings open to the public shall be available for inspection within 10 days after the approval of such records. So I'm sorry, it's going to take us 40 days before we can give that. I know FOIA's 5 days to 10 day response, but they're still not cleared. They need the initial 30 days and an additional 10 days of approval. So you're looking at 40 days before we can give you these minute meetings. quite frankly. Okay, beginning July 1, 2006. At the time, it complies with the order requirements of this subsection. A public body that has a website that the full-time staff of the public body maintains should post the minutes excuse me, of a regular meeting. Okay, the verbatim record may be destroyed without notification or approval of the Records Commission or the state archivist under the Local Records Act state no less than 18 months. Okay, beautiful. They gotta hold on. After 18 months, they could destroy. So that's why you gotta collect all this shit before they destroy you. Public body approves the destruction of a particular recording, and that's through the state archivist, and state archivist, which is the Secretary of State under the Local Records Act, destruction of record. The public body approves the destruction of particular recording, and number 2, the public body approves minutes of closed meetings that meet within written minutes requirements of subsection A of this section. Each public body shall periodically meet to review minutes of all closed meetings. Meetings to review minutes shall occur every 6 months, as soon thereafter as is practical, taking into account that the nature of the meeting schedule of the public body. Committees which are ad hoc in nature shall review closed session minutes as at the later of 6 months from the date. Let's look that up. Ad hoc. Ad hoc is an American eagle, is an American type of bird from the ad hoc. Okay, ad hoc is a word that originally comes from Latin and means for this situation. Okay, beautiful. Ad hoc. That's ad hoc. That's hogwash. Okay. At the next scheduled yada yada. Okay, we're gonna have to read this at a later time. Yeah, this is real heavy, powerful shit. Yeah, I'll read this at a later time. Where the provisions of this act are not complied with, or where there is probable cause to believe that the provisions of this act will not be complied with, that's a good one. Any person, including the state's attorney of the county in which such non-compliance may occur, may bring a civil action in the circuit court for the judicial circuit in which the alleged non-compliance has occurred or is about to occur, or in which the affected public body has its principal office, prior to within 60 days of the meeting alleged to be in violation of this act. Okay, like I said, yeah, public access counts, their opinions. Damn, this shit still goes the fuck on. Wow. Attendance by means of other than physical presence. Duty to post. Oh yeah. Duty to post information pertaining to benefits offered through the Illinois Municipal Retirement Fund. Okay, well, neither here, neither there. Well, I did a reading. Tooth Fairy came and spoke in my ear. Might be eligible. I might have to call this album Ad Hoc. I know New Normal, he doesn't like he calls rap music, or he calls crap, rap crap. But I think I'm eligible for a motivational, inspirational freestyle about FOIA, fuckery. Yeah, I think we're gonna shut this stream down, open up a brand new ticket, following right after. Well, you know what? I'm gonna be back on ad hoc ta. Ad hoc ta. Ad hoc ta. So What's Normal says, we have a secret government with a facade just like theater. Man, we gotta get What's Normal on the horn, man. I don't know if he's a robot or if he's a real, AAA, he's a T-Dotter, he's a fake Mike. Because he's intelligent, he's intelligent. Anyhow. Yeah, I think we're eligible for our session. We'll see, we'll see what we come up with. Anyhow, I'll be on in about 7 minutes. Refresh your browser. I'm going to shut this stream down. Thank you guys for watching. It was a great read. We read about half of the act. I think it's about 40 pages, this one. Not even about 30 pages. And the most important thing, let's remember, was that all meetings have to be recorded. There has to be date, time, verbatim their discussion. There has to be a fucking track log. So we skimmed through a lot of the compiled statutes and a lot of the fluff shit, but still the skipping is not the answer. We gotta read it all. Here it is. 5 ILCS 120/2.06. All public bodies shall keep written minutes of all their meetings, whether open or closed, and a verbatim record of all closed meetings. Oh, I'm sorry, that was a closed meeting. Well, okay, then I need the MP4 file, or I'm sorry, I need the WAV file for audio. Or I need the MP4 file, AVI file, for video recording. Yep. 5 days. I'll give you an extension, 10 days. So it's going to have the date, time, and all that on there. Okay, so do you guys want to tell me a flat, blatant lie? The FOIA officer's in a meeting? Okay, you're telling me the clerk is on a meeting. You're telling me the mayor's on a meeting. Beautiful, beautiful. I'm going to be requesting the written minutes of this meeting, but not limited to a audio or video recording. It's going to have the date and time according to 206, according to 0.06, 122.06. It's going to have the date, time, and it's going to have the members of the public body as recorded as either present or absent. Great job. Oh, our director is on vacation, but then he's present on these meetings. Do you hear that one, T-Dot? I'm sorry, our director, he's currently on vacation, or he's on sick leave, to come to find out that he was in a meeting that day and they lied and said he's on vacation, but it turns out that he's actually in a meeting. So this could go two ways if they want to play, conspiracy. This could go two ways. Oh, I'm sorry, he's off for today. He's on lunch, or he's on vacation as we speak. Great. Well, anyway, like I said, I'll be on in a few minutes. Thank you guys for tuning in. The one who encourages you to.